Good afternoon, everybody. My name is Len Lonzi. I'm the Managing Director of the Preccelerator program. And this is a program by a law firm, Stubbs Alderton Markiles. Our offices are in Sherman Oaks, and our Preccelerator program is here in Santa Monica, right on the promenade between Arizona and Santa Monica. We are open, and we have a couple of companies working out of our workspace right now. So I'm excited that even with the appropriate COVID protocols, we're able to get some people together. In the meantime, we have this brilliant workaround doing our webinars right here on Zoom. So with that, let's get started. It's my pleasure to introduce to you one of the partners at our firm, Kevin DeBré. Kevin is the chair of the firm's Intellectual Property and Technology Transactions Practice Group. He has worked on both sides of the equation. He's an innovator. He's a great attorney with great advice. He works from pre-formation to middle market in a broad spectrum of industries, from AI to VR. That's my abbreviated introduction of Kevin. You can read on our website his detailed bio. And with that, I'll present to you Kevin DeBré. Kevin, take it away.
Great. Thank you very much, Len. And thanks, everyone, for being here. Good afternoon. Welcome to Planning for Success, what entrepreneurs need to know about intellectual property. I'm just going to pause here on the title slide for a moment. Why Planning for Success? I chose the title of this presentation specifically because, in thinking about entrepreneurs, and I work with them often, entrepreneurs are a special breed of people. I mean, they're obsessed with their businesses, and that obsession carries through to the things that they do to manage their intellectual property. And so if you are an entrepreneur, you should be using the same discipline, the same obsession that you hold for your business or that you attend to your business that you would for intellectual property. So you're in this business, so to speak, you're in it to win it. And so the same thing goes with planning for success. Even though you're a startup, if you are, and an entrepreneur starting from a very early stage, what you're doing is you're taking the steps that you'll be glad that you took when you're a much bigger and successful company. So that's sort of the theme for the presentation this afternoon. And now my computer's frozen. There we go. All right, so here is the obligatory shameless self-promotion slide about our firm. Just in case you don't know about us, we're a full-service law firm here based in Los Angeles that provides services that most companies of all sizes, from startup to middle market to even public companies, publicly traded companies, need. Venture capital and corporate formation, financing. I run our intellectual property and technology transactions practice. We handle privacy and data security matters. And we have a vibrant mergers and acquisitions practice. And in those instances when things go a little bit sideways, we also have a business litigation group to defend and vigorously enforce rights that our clients have in those disputes. I like to say that we're not a large firm. I guess we're sort of a medium-sized firm, but we have full the capabilities of big law. So here's a little bit about me, and this is not just shameless self-promotion, but this really is intended to inform you about the perspective I bring to intellectual property. And I'll explain what I mean by that in a moment. So I was a former Silicon Valley lawyer. I was in Silicon Valley in the mid-90s with a major law firm representing tiny little companies like Cisco Systems, and I mean that sincerely. I was working with Cisco right after they went public, and they had 2 in-house lawyers. And it was a great time to be in Silicon Valley doing this kind of work. And that's the same sort of practice that I have here in Los Angeles at Stubbs Alderton Markiles, representing fast growth, emerging growth companies that use intellectual property of all types to build their businesses and build value. I'm also an advisor and startup mentor to entrepreneurs and companies. Before going to law school, I was an engineer, and I'm a registered patent attorney, but don't hold that against me. Years ago, I did file and prosecute patent applications, but really don't do that anymore. My practice is more in the area of commercialization. So if you see the Venn diagram below, you know, I look at intellectual property as having sort of three, sorry about this, channels or categories. Protection, that is filing and registering intellectual property, obtaining rights for protection. There's enforcement, which is going to court often and enforcing the rights against violators or defending the validity of intellectual property rights that have been obtained. My world, my practice is in the middle. It's kind of across of those other two areas, commercialization, which is working with businesses to form relationships that provide a path towards product development, developing new technology, and oftentimes commercializing technology to build value in their companies. And when I say this will inform you about the perspective that I come from, you know, a lot of times if you go to, let's say, a patent lawyer and ask, can I patent my invention? The patent lawyer often will say or respond, absolutely, we can do that. And the reason usually is not because they're financially motivated, but it's because that's what they do. And, you know, many patent lawyers that I know, they do it well. That's their focus. My response is a little bit different, and it is, what's your goal? What is the goal that you have in filing and obtaining a patent? And that goal can be offensive, defensive, you know, being more attractive to investors. There are a whole variety of reasons why one may decide to file a patent application for an invention. And as a business lawyer first, with expertise in intellectual property, what I'm interested in knowing is what my client wants to do with the intellectual property in building their business and how they're going to use it. So most entrepreneurs know that intellectual property is important. It can be a fortress to serve as a barrier against competitors. It's an asset that could be borrowed against. It could be sold. You know, patent portfolios are sold often. It can be a means for attracting investment. Investors will invest in companies that have solid intellectual property rights. And it also is somewhat of a validation. It can be a message to the consumer that the company is an innovator, a leader, a pioneer in the area of technology that the product or service is in. But even though many entrepreneurs know that intellectual property is important, very few really understand how to best protect, leverage, and maximize its value. So just starting with the basics, and what I'm going to do in this presentation is I want to build a solid foundation, give you a solid foundation of understanding what intellectual property law is here in the United States. And then we can build on that foundation, and that's when we get to the interesting part of the presentation, which is IP strategy. What things that you can do to protect intellectual property based upon the stage that your company is in. And then how to identify some common mistakes that entrepreneurs make with respect to intellectual property and how to avoid them. So there are 4 forms of US intellectual property protection. Patents protect inventions. Trade secrets protect non-public confidential information. Copyrights protect the expression of ideas, not the ideas themselves. And trademarks serve as like a message to the marketplace. It conveys information about the product or service that the trademark is associated with, that the consumer, the person who is receiving that message, can understand about the quality of the product, the source of the product. So for example, when you see a can of Coca-Cola, there's a message being sent there. You know what to expect inside that can in terms of quality, taste, etc. That's what trademarks do. They serve as this message to the market. Let's talk about patents first. So patents protect inventions, and these kinds of inventions could be compositions of matter, such as chemical compounds. They could be processes or methods. They can be machines, articles of manufacture, so they're called, or devices, and software could be patented through, it's actually a method. And even biological compounds that are artificially or made by human beings can be patented. That's patentable subject matter. So anything that is created by a human being, for the most part, is eligible for patent protection. Now, there are 3 requirements of patentability. It's got to be novel, couldn't have been invented before or hasn't been invented before. It's useful and not obvious. Not obvious based upon what has been invented before. The mistake that entrepreneurs often make is thinking that just by having a patent, they're going to have a successful business. And that isn't necessarily the case. Patents are powerful forms of intellectual property protection, but they do not necessarily create successful businesses. Now, here's an interesting point of fact. A 2017 Harvard Business School article cited a study of 34,215 of first-time patent applications by startups that found a patent granted to a startup company increases the startup's chances of securing funding by VCs by 47%. A 47% greater chance of getting funding as a startup by having a filed patent application. So you can take that for what it's worth. Patents are of interest to investors. But I think the real question has to be, what does the patent protect? How broad is the patent? And importantly, and you're going to hear me say this a number of times throughout this presentation, the value of a patent is your ability to enforce it. So patents, what's the power of patents? Why are they so powerful or important? Why do VCs like them? Well, they protect a wide variety of inventions, like I just mentioned. You don't have to commercialize the invention that is the subject of the patent. Some patents, many patents, in fact, just sit on the shelves and are not commercialized for a variety of reasons. And that goes to my point earlier of what is the goal in obtaining a patent? Sometimes the goal is enforcement. It's an offensive goal. It's to secure an area of innovation that industry is moving towards, that the patent holder can enforce, can take action against, and collect money damages in a patent infringement lawsuit. For some, that's a business. They can be, the real power is that patents can be enforced against innocent infringers. What's an innocent infringer? An innocent infringer is somebody who didn't even know about the patent, didn't know that the product or the chemical compound or the machine that was the subject of the patent was patented by somebody else, that somebody else had rights in it. They fell into the liability of patent infringement. And that's sort of the power and also the potential risk associated with patents is that they can be enforced against folks who don't even know the patent exists. And then they offer strong legal remedies. A patent infringer who willfully, knowingly infringes a patent could be at risk of a damages award of up to 3 times the amount of damages that the patent holder otherwise would have been able to recover. That's essentially punitive damages. So 3 times treble damages, that's a significant monetary award. And that's why the patent enforcement business is so attractive to a segment of investors. There are big money damages that can be awarded in these cases. And then a very strong remedy as well, is called equitable relief. That's an injunction. It's a court order to stop doing the thing that is infringing the patent holder's rights. And if the case is strong enough, that injunction can be ordered by the court in the very earliest days of a patent infringement case, very soon after the complaint is filed. And so you can think that, patent suit is filed, the motion to the court for preliminary injunction is made and granted, that essentially could wipe out the defendant before they've even had a jury trial as to whether or not they infringe. Now, I have to say that courts are very reluctant to grant that kind of remedy, but it is a remedy that is available in extreme cases for patent infringement. What's the downside of having a patent? Is there a downside? Well, yeah. It takes a long time to get a patent, and it's very expensive. It could cost $15,000 on up per invention, that's per patent, to obtain a patent. And this could take years. It could take 3, 4, 5, 6, even years or longer to obtain a patent. Now, when you think about some industries where technology is evolving very, very quickly, you got to think about how if you file a patent application in that industry where technology is evolving so quickly, the patent may not even issue in time before the technology has evolved beyond the invention. You find that in, for example, in the apparel industry. Even though certain types of apparel can be patented, it's an area that isn't very attractive or doesn't make sense oftentimes for patent protection because trends in the apparel industry are moving so quickly. As I said before, the value of a patent is your ability to enforce it, and enforcement is expensive. And that, a patent infringement case from beginning to through trial can cost $6 million. And that does not even include appeals. And it can take years to enforce a patent infringement case. But like I said, the damages can be very significant. And when you look at the cost of bringing a patent infringement suit as a startup, there's just no way you're going to be able to afford that, right? But that's why I was saying what I did earlier about planning for success. You're not going to be a startup forever. You're going to be a significant company with a significant business and significant revenues that someday may be able to afford that patent enforcement action. So in planning for success, in a sense, what you're doing by playing the patent game is you're planning for the future. You're making the bet that you can predict the future, that what you've invented is going to be something that industry, or competitors in your industry are going to want. And therefore, you're staking your claim in that area so that when that time comes, when you are that bigger, more lucrative company able to afford patent litigation, you'll be in a position to enforce that patent. One patent usually isn't enough. These days, the patent wars are fought with patent portfolios, which means several patents. So I often tell clients that if you're, the question often comes to me, well, can I patent my invention? And it doesn't really matter what the answer is, yes or no. What the analysis should be is patent protection going to be an integral part of your business planning, of your business strategy? I mean, you're not going to just, are you going to finish here with this one patent that you've budgeted for? That's not going to do you much good for two reasons. One, as I've mentioned here, you really should be sort of thinking about building a portfolio so that if in litigation, in enforcement, down the road, when you're a more successful company, if one patent gets knocked out because it's determined to be invalid, or the product or service that is accused of being infringing isn't infringing, you've got others you can rely upon. You have a backup plan. So you have other patents that you can sort of additional arrows in the quiver that you can use to enforce. That's the one reason why one patent is not enough, and you should budget for more than one patent. But the other reason is, and this is something that I've observed over the years of practice, is innovators continue to innovate. Your first invention is not your last invention. And so when you think about, what I've said before about how expensive patents are to obtain, and whether you should be planning for the future on obtaining patent protection, should also be thinking about budgeting. I'm going to probably have an improvement of this invention. So maybe I file on this one, but I should also be thinking about filing on the improvement in a year, and maybe diversification of my product offerings that I'm going to have 2, 3, 4 years from now. And so that's how you build a portfolio, is by continuing to innovate, having a team, and we'll get into this later when I talk about IP strategy, and having a team that continues to innovate and making informed decisions about whether it makes sense to file for patent protection. And then last, this always gets people scratching their heads, and I can't see you guys if you are, but I wouldn't be surprised if you do. Patents don't give you the right to do anything. You don't have the right to practice your invention. What they do is it provides a right to exclude, others from making, using, selling, offering for sale, and importing the invention that is the subject of the patent. Well, what does that mean? How can that be? I'm the inventor, and Kevin, you just said that in order to qualify for a patent, it has to be novel, not invented before, not obvious, useful. So I have a patent, and now you're saying that I don't even have the right to practice my invention. How does that make sense? It makes sense because it's possible that there could be other patents that dominate your invention, your patent. So I'll give you an example. So let's say you have a patent on a semiconductor, a microprocessor that's in a cell phone and allows you to send text messages from one cell phone to another, right? It's done, very easy, great, okay. But you don't have the patent, and somebody else has the patent on the cell phone network that enables cell phones to communicate. So in that case, if you don't have a license from the system patent owner, it's possible by enabling others to practice your patent, or even if you were to do it yourself, you'd be infringing the system patent. So that is why I say your patent on texting from cell phone to cell phone, providing the functionality within a phone that enables that to happen, doesn't give you the right to do it, because what all it does is it gives you the right to exclude others from doing what you've covered in your patent. Hopefully that's clear. Okay, so let's move on. Enough about patents, right? Let's move on to other forms of intellectual property. Trade secrets. Trade secrets are non-public confidential information. And these can include financial information, manufacturing information. even customer information, information about customers, not their names and addresses, because that often is public or may not be qualify as a trade secret, but information about customers such as, you know, quantities of orders or styles of products or product stock keeping units that they've ordered in the past. So what we're really talking about is non-public confidential information that provides the owner an advantage by being kept secret. So when I give this presentation live, you know, I'll ask a question. So who can give me an example of a trade secret that everybody knows and loves? And, you know, all the hands go up and somebody shouts out the Coca-Cola formula. And that's absolutely right. That's the Coca-Cola formula is a trade secret, and it's right here. Take a quick look. We're going to move on. But that is an example of very valuable intellectual property that has been maintained as a trade secret for over 100 years and is still enforceable and still valid. So what is the power of trade secrets? The power is that they have immediate effect. You don't have to file anything. You don't have to wait for the patent office to respond to your application. By creating the trade secret, it is in and of itself a form of intellectual property and protectable. And best thing of all, the protection can last forever, so long as the owner takes reasonable measures to maintain the secrecy of the trade secret. And what does that mean? That's a whole lecture in and of itself. But one example of that is, I'm sure you're all familiar with NDAs, non-disclosure agreements. It could be argued that by requiring somebody to sign a non-disclosure agreement promising to maintain the confidentiality of information that they're going to receive from you is a reasonable measure to maintain the secrecy of the information that you share with them. So it's things like that. You just have to be reasonable. You don't have to go over the top. And as companies get bigger, they have trade secret policies that ensure their employees and contractors abide by that requirement of maintaining secrecy. Trade secrets can enhance the value of other intellectual property. So what does that mean? I said earlier at the top of this presentation that intellectual property is an asset that can be sold or borrowed against. And, you know, if it is borrowed against then and taken as a security interest and the borrower defaults on the loan, then the lender can foreclose on the collateral, the intellectual property, and take possession of it. But oftentimes, what good is having, okay, now I've acquired this company's patents, or I bought this patent portfolio. A patent, and if any of you have read a patent, my condolences. But a patent is, it's like a recipe of how to make the patented invention. But a lot of times there is information that is useful for putting the patent into practice, to making the product that is covered by the patent that isn't included in the patent application. Where to source materials, for example, or you know, how to assemble them in a way that's cost efficient. These are examples of trade secrets, sometimes called know-how, that enable the effective use of patented inventions. So they kind of go hand in hand with trade secrets do with other forms of intellectual property to enhance the value of the overall package. And then finally, like other forms of intellectual property, trade secrets provide strong legal remedies. They could provide a recovery for lost profits and injunctions, kind of like what we discussed earlier. And in some cases, you've heard of corporate espionage. There are criminal penalties associated with trade secret theft. So this is a very powerful form, and I think underrated form of intellectual property. And the best thing of all is it's relatively cheap because you don't have to file anything or hire a patent lawyer to write something up that gets filed and registered with a government agency. But like other forms of intellectual property, trade secrets have their limitations. And one of those limitations is you got to keep it secret. You need to be diligent. You have to pay attention to the who you disclose the intellectual property to. I talked about non-disclosure agreements earlier, and one of the things that I find clients tend to do is they'll say, "Hey, Kevin, you know, we had this conversation with this this company, and it's great. They signed an NDA, and we disclosed everything, our source code, everything. It was great. You know, it's a marriage made in heaven." But you know what clients often, or companies, entrepreneurs often don't do, is keep track of who they've disclosed their intellectual property to, or their trade secrets, under what circumstances, what they've received in return from the other party, because oftentimes these non-disclosure agreements are mutually protective. Sorry about the noise outside. Working from home. So you have to be diligent and aware of when you disclose trade secrets. So I've provided some examples of having security procedures in place, legends, confidentiality legends on documents and computer files, identifying the confidential nature of the information contained in them, having agreements with employees and independent contractors to whom trade secrets are disclosed. Another, I guess, limitation of trade secrets is that reverse engineering and independent development is a complete defense. A defense to trade secret theft. There's no theft if somebody independently came up with the same trade secret on their own. And it is possible. Happens more often than you'd think, that people come up with the same idea or the same concept or information that's not publicly available, but you know it's in the zeitgeist, or you know just it's the nature of things. And so if somebody independently comes up with the same trade secret as you have and you've never disclosed it to them, then they are not going to be liable for misappropriation of that trade secret. Now, the third limitation is a little tricky. Enforcement can be difficult. And what I mean by that is it's not any deficiency in the law, it's a deficiency in, in the owners of the trade secret, because trade secrets, when they're stolen, need to be identified. And so it's kind of like the situation where, you know, if, and I'm just making this up as I go, so bear with me, but let's say you, and hopefully this doesn't happen, you go, leave the house for the afternoon, you come back and it's empty. Somebody came in and there was a burglary. I don't want to say robbed. I learned in law school that's not a robbery. So there was a burglary, and they stole all of your worldly possessions. Hopefully that doesn't happen. And when you are talking to the police and filing a police report, they're going to ask you, well, what was stolen? And you're going to go like this. Well, let's see, we had a TV, no, maybe 2 TVs and a couch, and same thing with trade secrets. Unless you've been diligent in keeping an inventory of your trade secrets, and often that means writing them down and storing them somewhere where you can access them, it's maybe difficult to enforce when somebody has stolen them and you know that they've stolen them, somebody you've done business with, and now you're going to go bring a lawsuit against them, and you're sitting across the table from a lawyer like me who's asking you, okay, so what were the trade secrets that, you know, your former business partner is using that used to belong to you? And if you haven't been diligent, it may be difficult to identify. Recently, I was involved in a in a case with a client, and I'm not a litigator, so I was brought in to sort of try to find a settlement, and I had one of my litigation partners there with me, and we asked the question, okay, so client, what are the trade secrets? Well, they're all right here, and I could tell you them. Now, what you need to do is you need to go away and write them down, and then come back to us, and then we'll go through them one by one. And it took him 2 to 3 weeks to diligently go down from memory through his, and he still had them, obviously, it's not like, a piece of furniture that is no longer there, but, to really think about, okay, what is it that constitutes a trade secret as that was stolen? Okay, and then what do you do about parties that refuse to sign NDAs? If you're an entrepreneur seeking funding from venture capital firms, you know better than to ask them to sign an NDA. Investors typically won't. Business partners sometimes, or potential business partners, won't, because they, they're concerned that you may claim that you gave them something that they didn't use, but nevertheless you're claiming that what you gave them ended up in their product. So what do you do? How do you use reasonable measures to maintain secrecy, to maintain your trade secret status, if somebody refuses to sign an NDA? I have some ideas and workarounds. I'm not going to get into them on this call, but that is an issue that comes up quite often. Let's talk about copyrights. As I mentioned before, copyrights protect the expressions of ideas. And this could be artwork by Juan Gris. It could be music recordings. If any of you are my age on this call, recognize 8-track tapes. It could be a movie, a film, a computer game. And the computer game, what I'm talking about there is the artwork, the content, the even the look and feel of the game. That's all protected by copyright. Scripts, manuscripts, books. The key to copyright protection is it needs to be fixed in a tangible medium of expression. So a musical score that's played in a symphony hall, in and of itself, the musical score, the music itself, as written and memorialized in writing, is protectable under copyright, but the performance itself is not protectable unless it's recorded by video or audio. So what is the power of copyrights? Copyrights have their own power, and that is that one of them is that they protect a wide variety of works, as I just described. And what copyrights protect against is unauthorized copying. And you see that often on the internet. Somebody has a piece of artwork, graphic art, that is available on the internet on their web page, and somebody takes a copy of that and puts it on their own website. Not a good idea, but it happens. And copyright protection provides a legal claim of infringement for making unauthorized copies. But it goes beyond just identical copies. It could include making something that is substantially similar to the copyrighted work, or even creating a derivative work, a modification, or embodying the work in a different form. So if you see a piece of artwork on the internet and it's 2-dimensional, let's say it's a painting by Juan Gris, and you have the inspiration to create a piece of sculpture based upon that painting, taking the still life that I showed here in the upper right-hand corner and making that into a 3-dimensional sculpture, that would be a derivative work. And if you didn't have authorization from the owner of the copyright, that would be infringement. Copyright registration, it's not like trade secrets. You do have to do something in order to enforce your copyright. Copyright is created at the time that the work is created, but in order to enforce the copyright against a violator, you need to register it with the Copyright Office. Fortunately, copyright is very easy. It's inexpensive. You can do it yourself, and it lasts a very long time. 70 years after the death of the creator, or 95 years if the creator was an employee of a company. It's 95 years after first publication, or 120 years after, let's see, whoops, I messed up here. Yeah, after creation. So 95 years after publication, or 120 years after creation. So very long time before it goes into the public domain. These days, copyrights do not need to be renewed. And so once they're created, last a very, very long time. And similar to the other forms of intellectual property that we discussed, there are strong legal remedies. There is a provision under the law to obtain up to $150,000 per infringing copy of the copyrighted work, regardless of how much damage the owner, or how much loss the owner of the copyright suffered. So this could be a very powerful form of remedy. In the days of Napster, when people were burning copyrighted songs from websites, from Napster, and getting hit with copyright infringement lawsuits from the recording industry of America, they were getting hit with lawsuits for millions and millions of dollars for this very reason, that it was based on $150,000 per infringing copy. And lost profits and injunctions are also available. But like the other forms of intellectual property that I've mentioned earlier, copyright has its limitations. It doesn't protect ideas. It doesn't protect functionality or methods of operation. It just protects the expression of the idea. And independent creation is a defense. So if a copy was not made, there's no infringement. And that is possible. If a person can prove they didn't have access to the copyrighted work, then there's not going to be infringement liability. The registration of software, so software, as I mentioned, is copyrightable, but registration of software can be cumbersome in that, each time a new version comes out, that could be the subject, or should be the subject, of a new registration. And so you can imagine, if you're a software company with multiple software products that are continuously being updated, you're going to need somebody or several people full-time managing the registration process for copyrights in those various software products. And then there's the issue of fair use. Fair use gets sort of a bad rep because people don't understand it. And what I like to say is, when people come to me and say, hey, Kevin, I copied this, work, and I'm using it in, our advertising materials, and is that okay? Because it's a fair use, right? I'm just, it's less than 25% of the verbiage, and that's a myth, that if you use less than 25%, then it's not copyright infringement. The first thing I'll often say to that person is, fair use is a defense. And defense means that you're being accused of something. And unless you're ready to be in that position of being on the wrong end of a lawsuit or a cease and desist letter, you're not going to want to really kind of rely on fair use. The other thing about fair use is it's a balancing test. So there really isn't a black and white, binary yes/no analysis of fair use. It is a balancing test. But there are certain precedents that have been in the law that one can rely upon, such as transformative use, which is where yes, it's a copy, but the use of the copyrighted work is for a different purpose. So an example of this in a famous case is where there are thumbnail photographs or images taken from a website that would appear on Google search results pages. And, you know, Google was sued for copying the images from those websites and putting them on the results pages. And their argument, which the court agreed with, is this is a transformative use. It's fair use because we're not taking these images and using them for the same purpose. And this was, let's say, an art site that was selling art. We're not selling art. What we're doing with these images is we're making it easier for people to navigate the internet by seeing what the result of their search is and then going to the website that matches what they're looking for. Transformative use. Parity is the same thing, or social commentary, where you are allowed to copy excerpts of manuscripts, books, articles, or even create a derivative work of them for the purpose of, you know, satire or making a statement that has social value. So I will, with that, move to trademarks. And as I mentioned before, trademarks are a message to the market. They protect the identity of the source of a product or service in the marketplace. And trademarks have their own power. They cover a wide variety of these identifiers of sources of products and services, from words and logos and slogans and patterns and colors to even sounds and smells. The MGM lion that roars, that is a registered trademark. Harley Davidson obtained a registered trademark for the sound of its engine. The key thing here is that it's distinctive, that consumers would recognize that identifier as being associated with the product or service that it is used with or marketed with. So you see the MGM line, you know what's coming. U.S. protection in the United States of trademarks can be achieved without filing anything with the U.S. Patent and Trademark Office. It's called common law rights, and they can be acquired through use in commerce. The benefit of registration is that it gives you nationwide coverage of your trademark. Registration, trade secret protection without registration under common law only protects the geographic area where the trademark has been used in commerce. So here's an example. In 1996, Amazon.com registered its trademark for Amazon selling books over the internet. And that gave them nationwide coverage of the term Amazon for selling books, except in one place, Minneapolis, Minnesota. Minneapolis had a feminist bookstore called the Amazon Bookstore that had been in business since 1977. And since they were first to use that trademark in connection with the same goods and services as Amazon had registered for, they had priority with respect to the geographic area where they were using their trademark. And there was nothing Amazon could do about it except take a license after being sued. Trademarks can last indefinitely so long as they are continued to be used in commerce. The idea here is that they are subject to renewal, and when you renew your trademark registration, you have to demonstrate to the trademark office that you're continuing to use it. Same thing in common law. So long as you don't abandon your trademark, it's effective protection. And then, like trade secrets, trademarks can enhance the value of other intellectual property. And Coca-Cola is a great example, that the Coca-Cola trademark is so widely known and so pervasive in being associated with a variety of products and licensed that is actually more valuable than the original trade secret of the Coca-Cola recipe. That's an example how Coca-Cola used a trade secret to leverage its awareness of the Coca-Cola trademark and how the trademark has acquired its own value of its own. So that's the foundation that I wanted to build. Oh, one more slide, sorry. The limitation slide. Every form of intellectual property has its limits. So descriptive and generic trademarks are not protectable. They have to be distinctive. So when you think of a descriptive trade, oftentimes technology entrepreneurs love trademarks that describe their product or their business because what they're doing is so technical that they want to just, give it to people. So, for example, I had a client years ago that was called telecommunication services. And what do? Is they provided telecommunication services. Not a good trademark. They ended up changing their trademark or adopting a trademark for TSI, and TSI became distinctive. You can lose rights through not using the trademark, through abandonment. Now, in the US, I mentioned that trademark rights can be acquired simply by using the trademark in commerce. And this is not true in many foreign countries. In many foreign countries, you could simply just register the trademark without using it. And this is a problem that comes up when using, let's say, foreign distributors of your product. So you make a product here, you have a foreign distributor, let's say in, I'll make up a country, Japan, and let's say Korea. And so they're on the ground, they're building the distribution channel for your product, and they go ahead and file a trademark registration in their name, not yours. And so when the distribution agreement ends with them, because maybe they breached, maybe you don't need them anymore, you found somebody else, they hold the trademark registration, not you. So squatters can block foreign registration or registration of your trademark in another country. And registration of a trademark can be canceled if it's misused. So that what that means is that trademark owners have a duty to what's called police the use of their marks. That means if they're aware of infringement, if you're aware of infringement or a violation, you don't always need to sue, and you don't always need to send a cease and desist letter, but you need to be thoughtful about how you would enforce your trademark to make sure, and here's the key phrase, to make sure that the consuming public that buys products with your trademark associated with it isn't confused. Remember, the whole idea of trademarks is providing metadata, providing information to the market about the source of your product. And if somebody else is out there with the same or a similar trademark, and you're not doing anything about it, now the public's confused, thinking, well, is it who's got the real, earbuds or AirPods? Is it Apple, or is it this, Granny Smith company that's out there that is calling themselves Apple? So, you need to, as a trademark owner, you have a duty and an obligation, and that comes with a cost, to police the use of your trademarks by others who use your trademarks without authorization, and importantly, by licensees, by those who you grant a trademark license to ensure that they're using your trademark in the same way that you would use it. Okay, now we built the foundation for understanding intellectual property law. I'm going to spend a few minutes talking about how to build an IP portfolio on a startup budget. So I look at IP strategy as a 4-phase, could be more, but a 4-phase process. And it depends upon the stage at which the company is in. So if you start from the bottom, startup company is in the development stage, it moves to validation, scaling up, and then maturity. Okay, so how does this come into effect, and why is this important? The reason is that what I've tried to impress upon you is that intellectual property protection is not cheap. and it requires a fair amount of attention. And as a startup, you have a lot of things you could spend money on besides lawyers. Although lawyers are important. And what you need to do is you need to get past this part here, the so-called valley of death. And that means where you're running out of money and you need to make it to your next round, and you need to get to a point with your product or service development and validation, proof of concept, and validation of market adoption, so that you will be able to attract investors. If you run out of money here, forget it. You're not going to get to this point where investors will see what you're doing and be able to de-risk the investment opportunity enough to want to give you funding. So what this means is you need to be very careful and conservative about how you spend your capital, and spending it on intellectual property it needs to be prudent. And as you grow and get more funding, this is a typical, no company is, no one company is the same as others. They're all different, but as you get more and more funding, more capital, more revenue in the company, you will find that you're able to expand your budget offerings, your budget to include a greater variety of intellectual property activities. And I'll explain what that means in a minute. So here we are in the development phase, business phase. You're developing your product, you're getting validation and proof of concept. You maybe have a proof of concept or an alpha version available. And what should you do? You should be IP aware. What does that mean? That means that you are cognizant of what you do with your intellectual property. Not like this guy who left his intellectual property somewhere and doesn't remember where or what it was. So what does this mean? Basic things. You have agreements with employees and independent contractors, making sure that the company owns the intellectual property they create. You keep track of inventions. You have an invention disclosure form that you have inventors on the team fill out and complete and maintain. And but maybe you don't necessarily file patent applications on those inventions. It depends on what they are and what your goals are, as I mentioned earlier. You have an inventory of trade secrets. You're creating a log. You're memorializing what those trade secrets are, how you use them, and why they're valuable to your company. And you're taking steps to maintain their secrecy. And you're doing testing on trademarks and brands that you are thinking about developing, seeing what reactions are by members of the market that you hope to address. The next stage is the validation stage. This is where now you're providing maybe a first iteration of your product or a prototype to a first customer, getting feedback from them, and you're now in a phase or a place where you can start implementing some IP processes, some discipline around the intellectual property protection steps that you are taking. And so what does that mean? That means that you are starting to think about intellectual property like a business person. You are starting to align the intellectual property that you are protecting with the business plan and business strategy that you've developed. And you're going to bring those two together. You don't want to have an end result where you have, oh yeah, we've got a bunch of intellectual property over here, and this is kind of the area where we're building our business. You really want to find that place of alignment between intellectual property protection and your business planning. Why is that important? Because that's where the value is. Intellectual property provides value if it enables your business to leverage its position in the marketplace, whether it's from a defensive position to create a barrier against competitors, or an offense position in the future where you can enforce those rights against infringers. That alignment is extremely important. And by the way, when there is a liquidity event in the offing, when a company is looking to acquire your company, that's what the buyer is going to be looking at. It's like, yeah, intellectual property sounds good, but really, what is it doing for you? How is it enhancing the value of the business? Where is it providing potential for future growth of the company? You should start or establish a screening criteria for patent filings. Like I said before, you take a patent or invention disclosure to a patent lawyer, and they're going to file a patent application for it. But before you do that, you should start thinking about, well, what are some of the pros and cons of filing a patent application? In terms of costs and how long it takes. And importantly, as I said before, and I said I would repeat this many times through the presentation, the value of a patent is your ability to enforce it. Would you be able to detect infringement of that patent if you saw somebody doing something, a competitor doing something, or come out with a product that looked like your invention, had the functionality of your invention, but you weren't sure if it was infringing your patent? And I'll give you an example. A process for that occurs on back-end systems for processing payment for purchase transactions that take place over the internet. You may have a patent on that process, but if you saw another company doing the same thing, you wouldn't be 100% certain that they were infringing your patent because you wouldn't have access to that back-end system. You would have to file a lawsuit, go through discovery or engage in discovery to find out, to get confirmation that, yes, indeed, they are following the same process that you have claimed in your issued patent. Unlike, for example, I don't have anything here, but an example is a chair, something tangible, visible, you can see it, and you could compare it to what you patented, and you could determine whether there's infringement. And then finally, in terms of implementing processes, trademark clearance searches and filings are important to ensure that before you go out to market with a brand, with a trademark, and building customer or consumer awareness of that brand, that you have done some searching to minimize the risk that you're going to violate somebody else's trademark rights, like the situation with Amazon and the Amazon bookstore. So I'll run through these next two phases quickly. There's the scale-up phase. You have validation. Now you're really starting to scale your business and increase the market penetration of your products, perhaps even going into foreign markets. You're diversifying your product offerings, and now you're in a position to build your IP portfolio. And even thinking about how you can start monetizing the value of the intellectual property that you have instituted processes to make informed decisions about for protection. So how do you go about doing this? One step is to accelerate innovation within your enterprise. And there are programs that companies have used to reward innovation and experimentation by their engineers and innovators to really increase the process of iterating on ideas and coming up with new inventions, even inventions that are outside of the areas that they're working on. Filing for foreign IP protection in markets that are going to be of strategic value to the company in the future. And then periodically going back and evaluating the patents and trademark filings that you have already made to determine if there's still relevance. Your business plan may have changed, so should your IP protection plan. And so by continuing to maintain at great expense patents and prosecute patent applications and trademark registration applications that no longer are relevant to the direction that your company is headed in can be wasteful, and not only in terms of capital, but also in terms of time and resources within your company. And so finally, we have the mature stage, and this is where a company is in a position to dominate their market position through the use of intellectual property. And this is why I like to say this is where you can use IP for BI or for business intelligence. And this is where you're starting to really think forward and think ahead in terms of anticipating where technology and industry are going and inventing, innovating, and protecting white spaces that aren't yet exploited. And you're taking proactive steps to maintain or to manage your expense, because as you build that portfolio, it's going to be expensive, and you want to really trim irrelevant or IP of marginal value from your portfolio. And you're also making make or buy decisions with respect to innovation in terms of acquiring other companies or acquiring other intellectual property. So it's no longer a sense of what you're creating in-house, but you're looking outside of the enterprise to see what can be acquired and making an assessment of whether it's better to build it yourself or acquire it. And then you're using tools to obtain information about your competitors, the competitive environment, where other companies are headed, how quickly they're filing patent applications in certain areas to get a sense of where they're devoting their R&D resources. There's a lot of information that you can obtain through analytics that's publicly, or the information that's publicly available that you could gain important inferences about by doing these analytics and using these software tools. So this is why I say, using intellectual property for business intelligence to really hone and develop and further your business plan. And so with that, I have about 10 more minutes where I could talk about IP mistakes, but I'm going to pause here and check with Len. Len, do we have questions from the audience that you think I should pause and take and answer?
Let's get to a couple of these. So Jonathan Tabbs, are you still on here?
Yeah, I'm still here.
John, you said you had a question regarding infringement precedents. Would you like to ask that?
Sure. Kevin, thanks for doing this. Something you brought up earlier, and you almost got to the finish line on answering my question, but it's all about the time between, especially with the life cycle you've talked about, from the startup all the way to when you have the money to actually enforce, which obviously is key. So many things can happen. So many decisions can be made about when you can spend the money to enforce, et cetera. With infringement and precedents that's set by other companies, whether it's that you didn't know that they were infringing or whether you knew, you just didn't have the bandwidth to be able to go after it. At what point does that patent that you filed at the beginning or at any time, at what point is it that there's really nothing you can do because somebody else has been trading with that information at all this time? Or are there remedies that go back in time to make you solid on whatever patent you owned or IP you owned?
Yeah, the remedies, so if we're talking about patents, the remedies go back to, and thank you, Jonathan, for your question. The remedies go back to when the alleged infringer was first made aware of or put on notice of the patent, of your patent. But you need to be careful. You don't want to say, hey, you're infringing my patent, because they're probably going to bring especially if they're a bigger company, bring a legal action against you to declare your patent invalid. And they may even do that in a distant court that they'll make you travel to. And it's a game of attrition. So you need to be careful by putting people on notice. At the same time, as you indicated, so you don't want to lose the opportunity when you are able to afford to take action against them, to do so. And so you need to be very mindful of, and I really highly recommend that you consult counsel on this, because this is a very tricky dance that you need to be, you can't say things, so like let's say make a demand that they stop and then go away, and you know, and then have a defense called latches set in, which means that they were able to, they just assumed that you went away, that what they were doing was okay. And they just, and then you come back 6 years later and say, oh, I'm back, now I have the money to sue you. And they're gonna say, well, you're too late. There's not a statute of limitations per se, but you just slept on your rights. So you need to be careful not to kind of, you know, poke the bear, right? But at the same, if you can't afford to defend, but at the same time, you need to sort of put them on notice so damages begin to accrue. And you don't want to wait too long or else you'll lose your opportunity because of defenses like latches or estoppel, which means, you know, by doing certain things or not doing things, they've taken, on your part, they've taken steps in reliance upon your inaction to their detriment now by you suing them. So they came out with a product and now they're really building up the marketing on that product, and you're sort of letting it go. So it's a balance, and there's no one size fits all, and you know, you really need to think these issues through with counsel when you confront them.
Okay, Abner had a question regarding, I guess.
Glad you're reading these, Len.
Yeah, I'm going to have Abner ask his question. Abner?
Hey, hey Kevin. Hey Len, thank you.
Abner.
Hey, what's up, Kevin? Hey, thanks for your time today. My question is, as you know, our company is called Checkplis, CHECKPLIS. So we recently discovered that there's a company called Payvita from Canada who filed a trademark for the word Checkplis, CHECKPLEASE. They have a product that provides payments and ordering functionalities for hospitality POS systems. It's spelled differently, but it sounds the same. Would this be a problem for us in the future?
Okay, so this is what I'm going to do. I don't want to address your situation because that could lead to a waiver of attorney-client privilege, which we don't want to have happen. So I will offer to you that I'm happy to talk to you about your particular situation offline. This week's a little bad for me, but you and I will talk. We'll set up a time to talk, and it will be at no charge. So that aside,
Nice. Thank you.
that aside, just generally speaking, the legal litmus test for trademark infringement is likelihood of confusion. And so that's an assessment of a number of factors, including whether the two trademarks, how similar they look, how similar they sound, the mental impression that they give in the consumer's mind, the channels of distribution that their products, respective products operate or sell in, how similar the products are. And so it's that sort of balancing test or that analysis that goes to whether the one mark is likely to be confused with the other marks so that consumers don't know the source of the product associated with that mark. So I'll leave it at that. Abner, you and I will talk about your particular situation.
And then we have.
Thank you very much, Kevin. Thanks, Len.
Thank you, Abner. And then there's one other person asked two questions. The first one is, can open source software be copyrighted? And then I'll let Joe ask the second question.
Okay, so open source software can be copyrighted before it goes open source because, well, let me put it this way. It depends on what kind of open source it is. If it's dedicated to the public domain, which some free software, open source software is, then it's not copyrightable. But I think where you're going with this is that open source software is protected by copyright. It's made freely available, i.e. without charge, but is subject to license limitations. It's subject to, you can use this software, but you have to provide an acknowledgement that we're the creators. And you can't you can't create source code, or you can't create a derivative work of this without publishing the source code, because this is part of a community project, a tech community project. What are they relying upon to impose those conditions on that open source license? Copyright. So the answer to your question is, in most cases where open source is subject to a license or license conditions, yes, it is protectable by copyright.
Right. And Joe, why don't you ask your second question?
Yeah. Can you hear me?
Yes, sir.
Yeah. Hi. Thank you, Kevin, for your time.
Sure.
For the first question, actually, the open source, the aim of having an open source is just to disclose that the code is clean in a sense that it doesn't have spyware, it doesn't have, privacy infringement code. This is the main aim of an open source in that regard. So it's like we're publishing our code just to make sure it's okay. And we still want to, preserve our rights related to this to this software.
So, yeah, I'm reluctant to give you specific advice on this presentation, but what I will say is software in general is eligible for copyright protection. Making it available to others for a limited purpose, in other words, we're making this available so that you can check our code, let us know if it's clean or if it's infringing, is a condition that you're putting on people's use or access to that code. And by the way, you may say, and I don't want you putting this into your product, you're just kind of giving us feedback. So you just need to be careful that by doing that, it can't be interpreted as a dedication to the public domain, in which you would be abandoning your copyright rights. So,
yeah. Okay, my second question is about financial instruments and product. Can we patent them? Like a special kind of bond or an option contract that differs from current available products and that have some genuine benefit for its users?
So I get questions all the time, like I said at the top of my presentation, from entrepreneurs who said, hey, can I patent my invention? And my answer is always the same, which is, it depends. What's your goal? What's your business goal? How are you going to use it in your business? So, but let me go beyond that and say that financial instruments in and of themselves, it might be patentable as a process, the use of those financial instruments to conduct certain transactions. And then if it falls within patentable subject matter, then the next analysis is, does it meet the 3 criteria? Novelty, non-obviousness, and usefulness. It sounds useful no matter what it is. I don't know if it's novel. I don't know if it's non-obvious. That's something that could be determined or assessed through a patentability search. I guess the question is, there has to be more to the invention than just a financial instrument. It's probably a process or a method for doing something that is embodied in a form of financial instrument.
Yeah, that's it. Actually, it's a process. Yeah, of course.
Yeah, and that's patentable subject matter.
Can I ask another question?
Let's move to the next one, and we'll catch up with you.
Actually, we're going to wrap it up. We're right at 1:30.
Okay.
And I want to be cognizant of people's time. If you need to contact Kevin, I'm sure his contact information is on one of these slides right there. Feel free to send him an email, and I'm sure he'll get back to you in a timely fashion. I want to thank everybody for your attendance today and your participation. Just one last housekeeping note. On Thursday of this week at 3:30, our Preccelerator is having its 15th demo day, and we invite you to come and learn about the companies that are coming through the Preccelerator. And if you have a brilliant idea and are looking for venture capital, we will have the opportunity to have you apply to the Preccelerator, and you can do that on our website. And then finally, this recording will be put up onto our YouTube channel under the Preccelerator program, and you will be able to listen to the entirety again, or if you missed pieces of it, to go back and refer to it. So with that, Kevin, thank you very, very much. Appreciate your time today out of your busy day, and thank you all for being part of our program today.
Yeah, my pleasure. Everyone take care, stay healthy.
All right, bye-bye.